Good morning, everyone. My name is Gail Day. I am the Executive Manager at the Free Market Foundation. It's my pleasure this morning to introduce Langa Bodlani. Many years ago, Langa was a researcher at the FMF. Today, he serves on the Free Market Foundation's Rule of Law Board of Advisors and is a member of the Johannesburg Bar. This morning, we are launching the 7th in a series of 8 booklets titled Laws Affecting Small Business. The series was first published by the FMF in the late 1990s. Sadly, red tape continues to strangle business and therefore the economy. So we have updated the series, which deals with finance, health, justice, labor, land, licensing, schooling, and tax. Langa will present justice today. Thank you, Langa.
Thank you, Gail, and morning to everyone. The title of the book is Laws Affecting Small Businesses, Justice. The book is a welcome intervention to tackling the many problems currently facing our legal system and, by extension, our social and economic lives. The synopsis in the book captures it very well, and I quote, "Justice for small business is essentially inaccessible, costly, and prohibitively time-consuming." The book has several recommendations, many of which are sound and I endorse, but there are others, few I must mention, with which I respectfully take issue. The book deals with the small claims court, the magistrates court, and all other courts, and finally has a section on judicial review. Before I deal with the overview of the book and the many recommendations contained therein, I must perhaps preface my talk with some contextual framework within which we must approach the topic of access to justice. And the first place to look to is the Constitution. Section 1, the founding provision of the Constitution, tells us that South Africa is a country based on the rule of law. Furthermore, in Section 34, the Constitution guarantees everyone the right to have any dispute that can be resolved by application of the law, decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. Lastly, Section 165, subsection 5 provides that an order of court or decision binds all persons to whom and all organs of state to which it applies. I will come to this later in my discussion. Now, our Supreme Court, the Constitutional Court, in Buckhazen versus Napier, Justice Ngobo, as he then was, stated, and I quote, "Our democratic order requires an orderly and fair resolution of disputes by court and other independent and impartial tribunals. This is fundamental to the stability of an orderly society. It is indeed vital to a society that, like ours, is founded on the rule of law." Section 34 gives an expression to this foundational value by guaranteeing to everyone the right to seek assistance of a court. End quote. Now, on the rule of law, this concept has received adequate exposition by our courts, but personally, I prefer Hayek's exposition in The Road to Serfdom, and I quote quite liberally from it. "Nothing distinguishes more clearly conditions in a free country from those in a country under arbitrary government than the observance of the former of the great principle known as the rule of law. Stripped of all technicalities, this means that government in all its actions is bound by the rules fixed and announced beforehand, rules which make it possible to foresee with fair certainty how the authority will use its coercive powers in given circumstances and to plan one's individual affairs on the basis of this knowledge. Hayek goes on to say, while every law restricts individual freedom to some extent by altering the means by which people may use in the pursuit of their aims, under the rule of law, government is prevented from stultifying individual efforts by ad hoc actions. Within the known rules of the game, the individual is free to pursue his personal ends and desires, certain that the powers of government will not be used deliberately to frustrate his efforts. Close quote. What is clear from this proposition is that the space, socially and economically, within which individuals plan their affairs must be maximized, and that in the regulation of that space, there must be little or no room for ad hoc government decisions. And to that we add red tape and inaccessible, expensive, and time-consuming dispute resolution fora. The primary business of any business is doing business and nothing more. The book aims to introduce interventions to maximize that space, and from this point of view is a welcome initiative. It must be widely read, especially by our legislators. That said, I doubt if lawyers will agree with everything in the book. On small claims court, we have already mentioned that our constitution envisages a system where individuals can have their disputes resolved by application of the law in a fair public hearing before a court or a tribunal. This is indeed our constitutional expression of access to justice. But as the book illustrates, the way in which our current legal system operates, access to justice is but a pipe dream, especially for small businesses. The book has 11 recommendations to revamp our small claims court regime to make it more effective for small businesses. The recommendations are: companies and incorporated individuals should have access to small claims court. Presently, only natural persons can institute a claim in a small claim court, and this is an anomaly because even in situations where those natural people form into a close corporation, they are still barred from using the small claim court. The monetary jurisdiction of the small claim court should be increased from what is currently 20,000 to 150,000, or such an amount as parties are able to agree. Currently, parties are allowed to consent to the jurisdiction of the magistrate's court, even though their claim far exceeds the monetary value. There is no reason why the same cannot be applicable to small claim courts. The monetary jurisdiction of small claims court should be subject to a mandatory annual review by the minister. Parties should be free to consent to the jurisdiction of the small claims court beyond the limit. The authors of the book recognize the possible problems that might ensue, and quite correctly in my view, such as the increase in the caseload of the small claims court. Presently, practicing lawyers volunteer their time to preside over this case, and the authors recommend that there is a need to consider compensation for these presiding officers, especially in the context of the increase in the caseload. Importantly, the idea of user charging those who use the court system, and that is now applicable to all court systems, especially those who have the capacity to pay, is long overdue. Parties already pay large amounts of money for private arbitration. Why should, for those who can afford, not pay for the court system? The further recommendations in the book are those dealing with cession of rights, interdict, claims for defamation, malicious prosecution, wrongful imprisonment, and arrest. I have an issue, elitist as it may sound, of extending the powers of the small claim court to grant interdictory powers. Interdicts, by their very nature, encroach on the individual space, either by prohibiting individuals from performing certain acts or ordering them to doing something. Failure or refusal to comply with a court order is a contempt of court and may attract sanctions akin to criminal sanctions. I am simply not comfortable with that scenario. This is important within the context of the constitutional provisions I mentioned earlier on in section 165, which says a court order is binding to those to whom it applies. My point is that it shouldn't be easy to get an interdict against anyone. There must be some level of stringency and the proper oversight of the process. And I am not too sure that that level of stringency is what is advocated in the book, especially when you consider that the rights of other individuals could be tampered with. Conceptually, there is nothing wrong with extending the powers of the small claim court to include claims for malicious prosecution, wrongful arrest, or imprisonment. It remains, however, to be seen whether practically this will be an effective system against a defendant state who has access to the bottomless state purse. The recommendation on mediation in small claims court can and should be implemented almost immediately. This is now a peremptory procedure in the high courts. As things stand, our government logic to small claim courts is, as opposed to relaxing access, as we had our constitution and the constitutional courts have pronounced, government is simply taking the opposite direction and introducing cumbersome and time-costly processes similar to the rules in the High Court and the Magistrates Court. These new rules are contained in the Government Gazette number R2573, dated 7 October 2022, entitled Rules Regulating Matters in Respect of the Small Claim Court. The intended changes that are envisaged in this Government Gazette are, in my view, retrogressive. They seek to be, for instance, prescriptive on matters such as contents of the letters of demand, the summons to be issued in the small claims court, and many other aspects of litigations where one would be expecting relaxation rather than what this Government Gazette aims at. I now go to dealing with the Magistrates Court. The recommendation of introducing short process court to deal with enormous delay is not problematic at all and can be implemented almost immediately. The recommendation 15 says litigants in any court that is should have the right of assistance of their choice. The authors say that justice and access to justice will be enhanced if litigants have the right to be assisted in any court, even by non-professional lawyers. The current system is a job reservation for professional lawyers, and the suggestion is that even lay people should be allowed to represent others in court. I must say, there is already a trend towards this move, especially in the labor court, where an employee can easily be represented by a fellow trade unionist. So at a practical level, this should already be happening. The recommendation, however, with respect, does not seem to fully appreciate our adversarial system of common law. In the inquisitorial system of civil law, the proceedings are judge-led. He seeks the truth and decides the evidence to hear and ask the most important questions. Our system, by contrast, is advocate-led. It is the legal representative who decides what evidence to call and what questions to ask, and the judge sits on what is called and tested. The judge sits as an independent umpire. For the lawyer, the system is about the test of the evidence and not necessarily the truth or even the justice of the matter. The system is supposed to work on the assumption that lawyers are evenly balanced and can cancel each other out, and the judge is there to determine the case after hearing each side. Truth of the matter is that not even lawyers are evenly balanced. How much more will the scale be tipped where an experienced lawyer is tipped against a lay representative? Can we say justice is achieved? For this particular recommendation to be more appealing in my view and with respect, I think we need more to revamp our adversarial system in order to factor in this recommendation. The recommendation on judicial review along the lines of the US Regulatory Flexibility Act and Small Business Regulatory Enforcement Fairness Act is long overdue. In the US, as the authors point, the agencies take steps to collect inputs from small entities on regulations to determine whether the rule is expected to have a significant economic impact. I am not too sure if our Department of Planning, Monitoring and Evaluation is up to this. And finally, Gail, to the extent that I did justice to the book, I take credit. But where I fail, blame should be attributed to Temba, Leon, and Eustace, who together are my mentors. Thank you.
Thank you very much indeed for that, Langa. I really appreciate you taking the time this morning to give us your views on our laws affecting small booklet, business booklet. Does anybody have any questions? You can either just unmute yourself and perhaps put your hand up or interrupt, or I'll also just check the chat. Temba, I see you've joined us.
Yes. Uh, Langa, I really very much appreciate the fact that you've been quite candid and straight to the point and focused. And also, one gets the impression that you really studied that book very carefully, especially in the context of the South African law system, the judicial system. And so in the process, there's a lot of wisdom that you've imparted to us. And I'm also very pleased that you've homed in on the major highlights of the book and commented very elaborately on them. The question that I want to ask is, overall, uh, you do endorse the the books the book's recommendations in terms of how the system could be overhauled so that there is easy access to justice for especially small business entities and individuals as well. And the question is, sorry for being slightly long-winded, I should not monopolize the time. Who in Parliament do you think it would benefit for this book particularly to send through to? I know that the state law advisors would be one target for the book. I think all of them, if they could be quantified, should each have a copy of this book particularly. And I think also the whole set of the books should be sent to the president of the country At least so he knows where we're coming from. He knows he can acquaint himself with the rational arguments for, as he put it from his perspective, deregulating the economy, deregulating, the institutions so that they become smart institutions that are carefully targeted and do not impose any onerous financial regulatory costs on the people and businesses. So it's more of a rhetorical question than actually a question that I'm directing to you. Thank you very much, Langa.
Uh, Thank you, Temba. When I read the government gazette, I became extremely concerned that the idea behind introducing these amendments, in the views of the bureaucracy, perhaps they seek, and I know that I'm assuming what I'm about to say, they seem to think that streamlining the rules in the small claim courts with those in the high courts and the magistrates court, the rules in the magistrates court are now similar to the rules in the high court. Anyone who practices law will tell you that for each case, they may be 30 or 40 years into practice, they still consult the rules book, Erasmus. And my concern is that if you are going to introduce the similar rules to small claims court, it defeats the purpose of having the small claims court. I mentioned in my presentation that the amendment seeks to introduce prescriptive terms on how a letter of demand should look like and what it should contain, what the summons should look like and what it should contain. It doesn't tell us what the failures to comply with those prescriptive terms will result in. So, to answer your question, is that I think that this book immediately should be sent to the state law advisors, especially those in the Department of Justice, because these recommendations seem to come from them. But I will also venture to say that all legislators should have a copy of that book and all these books, because they are the ones that really enact the laws that affect all of us. But immediately, and perhaps from a practical point of view, we need now to be raising, because I came across these amendments in relation to small claims court, when I was doing my research. I don't think that there's wide publications, people know about this. And my worry is this: the amendments are an antithesis to what this book seeks to achieve, and immediately we should counter that by any means that we have, including writing to this portfolio committee, stopping these amendments. But these books generally, and I must confess, there aren't many that I have read, but I know the previous editions. I've read all the copies of the previous editions, should be available to our legislators in the national and provincial legislators, and not just to the opposition benches, but to all the benches.
Thank you very much indeed, Langa. I see that Zakes has a question. Zakes?
Hi. Thank you for the talk, Mr. Bodlani.
You're welcome, Zakele.
Yes, I have a question. During your presentation, you mentioned the contrast between the inquisitorial system, I think, and the adversarial system.
That's correct.
Yeah, is there a specific system you would favor as better enabling broader access to justice, or pretty much solving the problems you aim to solve between the two?
The reason I brought, and there's no particular system, I think I am really comfortable with the system that we have, the adversarial system. And the reason I brought that is to comment on the recommendation that says that. And I take it that the aim is really to untangle the job preservation that lawyers have, the monopoly. So from an ideological point of view, I think I agree with the recommendation that says that representations in courts should be by choice. So if I have a matter and Temba is available and capable to represent me, I shouldn't be stopped. I should have. And I said that perhaps that is already happening because in the labor sector, a trade unionist who may or may not be legally trained can represent someone else. So to answer your question is my reference to both systems was specific to the recommendation. I have my my misgivings, and I said I contrasted an experienced senior counsel. If Norman Davis is here with me, I am evenly balanced, not evenly balanced in relation to that senior counsel. And the question I was really bringing to the floor is whether or not in that scenario, can we say if I, Langa Bodlani, of 3 years in practice, I'm pitted against a senior counsel, how much more a person who's not legally trained, can we that say in that scenario justice is achieved? I've not thought so far to whether or not the inquisitorial system is better suited than our adversarial system with a view to achieving access to justice. I just think that maybe we need more, we need to think more on that question, but I am also not certain whether our pondering on that question will yield to anything. I don't see a revamp. Maybe we need to take some aspects of the inquisitorial system and introduce it to our system and have a system that maximizes access to justice rather than what we are having. And the recommendation is sound, but I'm just looking at the practical effect and whether or not with that scenario operating, can we say access to justice is achieved?
Okay. Thank you, sir. And as a parting comment, really mentioning your issue that you have in terms of the discrepancy, really, like there's already a discrepancy, as you mentioned, that if you were as a person who's not silk were to go up against someone who's silk, there would be a discrepancy in terms of the quality of representation you'll be able to give. So if that is a reason for maybe being opposed to the possibility of that being an instance of a layman against a professional, then like the instance of a difference in skills at the very least concerning things like grasp of the law, rhetoric, and the ability to construct arguments already exists within our current system. So this isn't necessarily a comment. I'm sorry, this isn't necessarily a question, but more than a comment, really saying that like your worry about what would happen should at the very least the recommendation be taken into consideration practically is already happening practically. At the very least, it is expressed by the amount of money one can pay for legal representation, which tends to determine whether the quality thereof.
I take that.
Thank you, sir.
Thanks.
Thank you, Zex. Are there any other questions? Just check the chat room and see if there have been any questions typed there. I think that was Zex's question. Anybody else like to say something or ask Langa anything? If not, I'm going to just say Thank you very much indeed again for joining us, Langa. It was wonderful to see you. And thank you for all the time and effort that you put into this. And to those of you listening, we will be posting Langa's presentation onto our website, along with the booklet, the content of the booklet, and of all of the others. And then next week is the last in the series. We will be launching Laws Affecting Small Business Finance. So we'll be in touch with you then. Thank you, everybody.
Thank you.
Bye-bye.
Thank you. Bye-bye.